Hello friends, greetings to all watching the video. I welcome you all to another episode of Convo with Apricus. Friends, our topic of discussion today is healthcare justice and legal scenario, global to Indian perspective. And to throw light on this topic, we have Dr. Bhupinder Singh with us. Dr. Singh is Associate Professor in the Department of Law, Christ University, Delhi-NCR Campus, in India. He has vast experience in teaching and research and also many publications to his credit. He is also an honorary member of editorial board in Justice and Law Bulletin. Welcome, sir. Welcome to Convo with Apricus. It's great to have you here for the discussion. We will start the discussion now. Sir, what is healthcare justice?
Yes.
How can it be attained?
Yes. So first of all, thank you so much, ma'am, for inviting me and to discuss this really important topic, because this the health care and health justice is really important for all of us. And we try to elaborate this topic from different dimensions. I have PowerPoint presentations on it, and accordingly we proceed with this. So health justice and legal scenario from this global to Indian perspective, this is a broad topic for today's discussion. So health justice means where the justice from health point of view is given to each and everyone, which is not only limited to your physical health. It is also include your mental health, your spiritual health, and for this, to achieve this health justice, legal provisions are there from global level to Indian perspective, where at grassroots level the benefits are given to the people. So this health justice is really, when we are talking about the quality of care, the quality of life included in this. So health in broader sense means is the quality of life, and where the WHO defined this, health means a state of complete physical, mental, and social well-being, not merely an absence of disease or infirmity. So they include physical, they include mental, they include spiritual, they include psychological health as well. So this same is with the Oxford and Black's Law Dictionary, where the state of being sound, where your functions are efficiently discharged. So health justice means providing each and every kind of facilities for your good health, which may be from the health infrastructure, which from the food quality, which is from the provisions of the healthcare, the WHO provisions, which is applicable to India, along with the provisions from the Constitution of India as well, where the specific right to life and personal liberty is there. Under this, the right to immediate medical care is given. So this is the proper, you can say, the elaboration of this health justice concept.
Thank you, sir. Sir, according to law, what health benefits the citizens are entitled to?
Yes, so we have multiple health benefits according to the law. Like we have the provisions from Constitution of India 1950, where the fundamental rights are there, and according to Article 21, it includes the quality of life. Means the, according to this Francis Corley versus Administration Union Territory of Delhi, where they held right to life include right to live with human dignity. According to this, human dignity means you fulfill the bare necessities of life, like adequate nutrition, clothing, shelter, and other facilities. Same with the case law belong to this Chameli Singh versus State of Uttar Pradesh, and this Ekta Shakti Foundation case, Subhash Kumar case. In each and every case, the judiciary specify about these are the benefits which should be given to the people belong to India, from environment point of view, from this health measures, from the protection from overcrowding as well, the freedom from malnutrition as well. Along with this, we have really the landmark judgment here from the Supreme Court of India. It's about Permanent Katara versus Union of India case, where the immediate medical care should be given to the people. With this, we have the protection from environment pollutions and health hazards, where they properly taken care of the sanitation, preservation, as well as the maintenance of health. Along with this, not only from the fundamental rights, from the legal point of view, we have the directive principle of state policy, where the case laws as well as the articles are there, which provide direct as well as the indirect protection to your health. And these are the other initiatives from legal point of view. We have a number of committees, 5-year plans, national health mission also there, like national urban health mission, rural health mission also there, programs on mental care, program on nutrition, program on this the physical health as well. Schemes and policies are also there. So these all from legal point of view, from the legislative point of view for the protection of our health.
Thank you, sir. Thank you for the information. Sir, in case of non-accessibility to accessibility to healthcare benefits, where should the citizens go? What are their
Yes.
rights in this regard?
Yes. So in case non-fulfillment, again, from legal points, these things are already available. The fundamental right they have, and they approach to the Supreme Court as well as to the High Court of India in case the violation of fundamental rights. So in case non-fulfillment, then they approach to the Supreme Court as well as to the High Court. And secondly, the viable solutions when we are talking about is the provisions from this the Indian Penal Code 1860 we have, where specific aspects belong to the offenses which are affecting public health, safety, convenience, decency, and morals. Along with this, we have the provisions from the CPC, CRPC, law of tort, and the consumer protection. Ultimately, as a patient, we all are consumer, and according to 2019 Consumer Protection Act, you approach to the consumer form in case you require grievance, as well as you require the compensation in case any medical negligence happen. In case any civil kind of provisions, then you approach to the with the provisions of the law of tort and criminal procedure, civil procedure as well, and from IPC provisions as well, you approach to the normal court in case any violence, in case any kind of crime is committed by the people belong to this medical field, and non-availability, negligence kind of things. So yes, these are the provisions, and you approach to the courts from via these solutions and the provisions from the legal point of view.
Thank you, sir. Sir, what is ethical principle of justice in healthcare?
Yes, so ethical principles, when we are talking about from this healthcare point of view, is about the duty of the doctor is to take care. And in this scenario, along with this, we have these legislations. These are broad legislations which provide you the proper medical health facilities from your nutrition point of view, from your mental point of view. Like the first one is about the Mental Health Act 2017, where it properly take care of the mentally ill people. And the ethical practices from medical field is about to treat the patient with proper care and with proper facilities. Second is about the Food Adulteration Act 1954, prevention is there, where in case any kind of mixture, in case of any kind of adulteration, then it will take care your food, and the punishment penalties are also there. Third one is really important, the Consumer Protection Act 2019, where the in case any unethical practices, in case any kind of negligence, in case any kind of negligent kind of things are there from the hospital, from the medical staff, from the doctor, then you approach to the district form, state form, and national consumer form according to the jurisdiction belong to this court for the relief, to get medically the relief from any kind of negligence happen. Then the fourth one is about, we have this medical maternity benefit act from medical point of view. In case any pregnant lady belong to any institution as a employee, then the ethical practice in this scenario is about to provide the medical relief as well as the maternity protections, where the 26-week leaves with wage or with salaries there, and also to provide the child from any kind of malpractices, any kind of violations, exploitations under the Child Labor Prohibition Regulation and Amendment Act. And last one is the Essential Commodity Act 1955, where again the ethical practice from the government is about to provide you the essential commodity on a reasonable price, so that each and every one will get or accessible to all the basic requirement of food for the fulfillment of the nutrition part. So these all are the ethical practices from the government, from the hospital, from the people belong to different dimensions.
Thank you, sir. Thank you for explaining in such a nice manner. Sir, please explain the scenario of healthcare justice at the global level.
Yes. So according to global level, we have multiple aspects. Like I have two presentations on this. One is about the international organization, where the International Labour Organization 1999 in India already a member from its inception from 1919, before independence even, where this organization specifically worked for the employee, for the worker, for the protection of healthcare. Maternity protection is also a part of this healthcare. Second is the Food and Agriculture Organization we have, which specifically focused on eliminating hunger, food insecurity, and malnutrition. So the implementation of these provisions in India, according to Article 253 of Constitution of India as well. Third is the UNICEF, according to 1946 provisions. It provide emergency food, healthcare to the children, as well as to ensure the children get care and education. Now, the important one, which is really concerned about the healthcare, is about the WHO 1948. So here, it's a leadership in healthcare. It's fostering the health security, strengthening health system within the sphere of international law. And same, we all follow from last 2 years, because we suffered from this COVID-19 from last 2 year and 3 months. So in this scenario as well, we follow the protocols, the directions by the WHO. So this is really important aspect belong to the healthcare, health justice point of view. And these are the last where the declarations and conventions are there for the children, for the human being, from this human right perspective. When we're talking about the justice, so justice, ultimately everyone has a right to standard of living which is adequate for health, well-being, food, clothing, housing, medical care. And I also examined world's constitution as well, where they provide specific fundamental right for the healthcare, for the public health, for the global health, for the health justice, as compared to India, where we have Article 21. Under this, the obviously the health rights are there, but still we need to improve, and accordingly we provide justice to each and everyone from health point of view.
Thank you, sir. One more question I would like to ask. Sir, in the post-COVID era, what initiatives would you expect the government to make in the law so that health benefits are distributed evenly in the society?
Yes. So these are the viable solutions I have, where we provide more effective health justice, treatment, diagnose, and save ourselves, and from the government point of view, the public from any communicable, non-communicable disease, like this kind of this swine flu, and then this the metavirus, and now this the COVID, and number of other things happen earlier as well. So we need the comprehensive public health legislation on this, because in the absence of a specific legislation, we don't have any definition of public health care, health justice. So in case we have legislation, it means we cover each and every aspects belong to this physical, mental, and spiritual health care. Second is the proper implementation of international healthcare provisions in India, where majority of things at international level only the guidelines. But in case we implement properly, it means we follow properly the guidelines, like in this COVID-19, the mask and sanitization, hygiene kind of things. So now we properly aware and follow from this legal, from social point of view, the provisions at international level in India as well. Third is we require specific healthcare right under the Constitution of India 1950, so that we approach to the court in case of violation of fundamental rights. And last one, we have this remedy under law of tort, consumer protection, contract, and criminal law from civil, from criminal point of view, so that we improve our infrastructure, we provide the equality, the equity of healthcare, which ensure the health justice, which also ensure the accountability of the people involved in this kind of profession, the doctor, nurse, medical staff, along with the proper accountability, implementation, and the enforcement of law, which specifically dealing with the health justice. So these all are from each and every aspects which require attention, so that after this post-COVID era, we work on it and then we provide the viable solutions to the people.
Thank you, sir. Thank you so much for explaining the topic in such a lucid manner. And I would like to thank you that you came here to part in the discussion and explain the topic very nicely. Thank you so much, sir.
Thank you so much. Thank you so much.